Here's the truth no one will tell you. Even most personal injury attorneys will not admit to this. Justice system does not care about how badly you were hurt from an accident, how badly you need your money, or what you need your money for. Whether it's to pay your rent, pay your medical bills, or pay for your prescription medication or treatment just to get better and survive. Our justice system is slow. It is painfully slow. And in a personal injury case, there is no such thing as the right to a speedy trial. And when I have clients that come to me who are injured in an accident, whether it's a car accident, a construction accident, a fall case, cosmetic injuries, a dog attack, whatever the case may be, one of the hardest things I have to do as an attorney is explain to my client how long the legal process will take, how long their case will take from beginning to end. It isn't hard because I don't know the answer and I don't know how to explain it to them. It is hard for them to hear because they cannot understand why they are not getting a check immediately. They were in an accident, it wasn't their fault, and they were injured. So why aren't they getting paid next week? And when I'm speaking to a new client, one of the first questions they will ask is, how long is it going to take? I get that question almost every day. In this video, I'm going to explain to you our process, what we do to move a case along, how long a case typically takes, what we can do to speed it up, and the obstacles we have to overcome in order to bring it to a fair and just resolution for all of you. My name is Phil Rizzuto of the Rizzuto Injury Firm. We represent clients who are injured in accidents throughout all 5 boroughs in New York City, all over Long Island, Westchester, and beyond. There are 3 core factors that are needed in every personal injury case in order to be successful. If one of these factors don't exist, it is an uphill battle. These are liability or negligence. Somebody has to be at fault for causing an accident. Negligence is defined as the failure to use reasonable care under the circumstances then and there existing at the time of the accident. The second element is there has to be an injury caused by the neglect. In New York State, if you're injured in a car accident, we have to be able to prove with medical documentation that you sustained the serious injury as defined under the New York State insurance law. A serious injury is defined as death, loss of a limb, loss of a fetus, significant disfigurement, a fracture. Those are what I consider the obvious categories. A medically determined injury that impairs your usual and customary daily activities for 90 out of 180 days immediately following the accident. A doctor must say you can't do what you do on a daily basis for 90 out of 180 days immediately following the accident. So if you don't go to work, if you don't go to school, if you're unable to do your household chores and you have to hire people to clean your house or mow your lawn because you can't do it, or if you're working and you're placed on limited duty, that is an impairment of your usual and customary daily activities following the accident. And it has to be a specific window for 90 out of 180 days immediately following the accident. And finally, there has to be a deep pocket that can pay for the injuries caused by somebody else's neglect. That is usually an insurance company. In a car accident case, the minimum amount of insurance coverage vehicles are required to have if they're driving in the state of New York is only $25,000. Now that is the minimum amount of insurance. Some vehicles have 100, some vehicles have 500. Some vehicles have what is called an excess or an umbrella policy, and it is higher. But the insurance coverage has to exist in order to get a recovery for the injuries you sustained from somebody else's negligence. People that only have $25,000 worth of insurance coverage are not really concerned about losing their assets because it's an economic factor. Right? They can't afford higher coverage. So if you can't afford higher coverage, you don't have that much to lose. Commercial vehicles and commercial accidents involving businesses or buildings have higher limits. Usually the minimum amount of insurance against a commercial defendant, that is the person who is negligent who would be suing, has at least $1 million in coverage. So these 3 factors not only help determine whether or not you will be successful in recovering, but they also play a factor in how long your case will take. Now, a lot of times, determining who's at fault is easy and it's very clear. If you're in a car accident and somebody strikes you in the rear, they're negligent and you will have 100% liability against them. Sometimes it's not so clear. 2 drivers can have 2 different versions of how the accident happened, and it is the plaintiff plaintiff's burden, the person who was injured and bringing the lawsuit, to prove that the other vehicle was negligent. Sometimes there's an issue of comparative negligence where both people are at fault. Premises cases are different altogether because in order to succeed on a trip and fall or a slip and fall in New York, we have to be able to prove that the defendant who was negligent had notice of the condition. Notice means that they actually knew of the condition, that they created the condition, or that the condition existed long enough that they should have known about it and have had an opportunity to correct it. If you fall in the middle of a snowstorm, that is called a storm in progress, and the likelihood of holding the defendant negligent is slim to none. However, if it snows today and the defendant clears the sidewalk or the walkway or the parking lot or whatever it is, and tomorrow there's patches of ice all over the place and you fall, that may be a case because it shows that they didn't really do a good job in cleaning it. And who's responsible? That's the subject of a whole other video, because it starts with the property owner, could be a maintenance company, could be a snow removal company, or whoever the building owner decides to point the finger at. And those cases will typically take longer because liability is never that clear, and who's actually at fault is also not clear, and we need to make a determination as to who has the responsibility, and it may be multiple people. So if that's the case, those cases are going to take even longer and are going to involve litigation and could take years to resolve. Now, as far as injuries go, we don't live in medieval times where we take an eye for an eye or a tooth for a tooth. The only remedy we have available to compensate people who are injured through the negligence of others is a monetary one. It's a monetary remedy, and the purpose behind it, it's supposed to make them whole and compensate them for what has been taken away as a result of somebody else's negligence. Evaluating injuries is not easy, and it is far from clear-cut, because how can you put a value on somebody's pain and suffering and what they went through? And what this person went through may be different than what that person went through. How people heal are different. Age is also a big factor in making a determination as to evaluation. If we were dealing with objects, if we were dealing with cars or paintings or anything physical, we would have a receipt and we would say this is what it cost. We can have an appraiser come in and evaluate it, but evaluating pain and suffering and emotional distress and what was taken away from somebody as a result of an accident is not that easy of a task. Now, how we do it? Well, injuries are broken down into two basic components. There's a component of past pain and suffering, which means how was a person injured from the date of the accident up until the date of a verdict or a settlement. That is the past pain and suffering that is taken into account when evaluating injuries. And it's not only pain and suffering, it's past medical expenses, it's past out-of-pocket expenses for travel, household help, prescription medication, medical treatment, physical therapy, diagnostic testing, lost wages, and future damages are calculated over a person's life expectancy. For simplicity, I use 80 years. There is actually a chart in a book called the Patent Jury Instructions, which will tell you what a person's life expectancy is. I say it's around 80 years. Sometimes it's a little less, sometimes it's more, depending on the person's health situation, the person on whether they're male or female, and race is also a factor in determining a person's life expectancy. But if a person is seriously injured and they're going to have to receive medical treatment throughout their life, pay for diagnostic testing and medical expenses, and their work life expectancy is going to be cut short or maybe completely eliminated, they can be compensated for future pain and suffering from the date of the verdict over the course of their life expectancy. So for somebody who's 20 years old, that can be another 60 years. For somebody who's 50 years old, it could be another 30 years. We have to take into consideration what the injuries are, what treatment did the person receive, what treatment has been recommended, what diagnostic testing was done, and what were the results, what medications has the person been taking, what medical devices were required or will be required. These are all factors that go into evaluating injuries. Insurance companies have their own way of evaluating injury. And I know because I used to do insurance defense work. Insurance companies have a program. It used to be called Colossus. I'm not sure if it's still called Colossus or something else today. They had a system known as Colossus, and they would input your age, your injuries, and every time you went to the doctor would be input into this program. And then it would spit out about what your case was worth. Part of the problem with this system is it doesn't take into consideration the human factor, how a person is feeling, how a person feels on a day-to-day basis. Because the reality of injuries are, you can get all the treatment in the world, and maybe it'll make you better temporarily. Maybe you'll feel better right after the treatment. Maybe you won't. If it's not going to heal you, especially when it comes to soft tissue, neck and back injuries, those injuries could be the worst. And there is not much that can be done to heal them, ever. And believe it or not, most people are not litigious. Most people don't want a lawsuit. Most people wish they were never injured and want to go on with their lives. And most people need to work in order to pay their mortgage, to pay their rent, to buy food, to pay for insurance. They need to actually go to work and suck it up when they are hurt, no matter how badly they are injured. These insurance company programs do not take that into consideration. They just look at the numbers. They look at the injury, they look at the number of times you went for treatment, they look at your age, they look at your occupation, and they come up with an evaluation. How we evaluate cases is much different. First, we consider liability. What is a liability situation? Is it 100%? Is it 50-50? Maybe sometimes we have cases where liability is really tough and even less than 50%. But whatever it is, we come to an evaluation of liability. Once we have that percentage, we multiply it by what we think the value of the injuries are. Again, evaluating injuries is not easy. We take into consideration past pain and suffering and damages and future pain and suffering and damages. And based upon past cases, not only through our office, but through the history of the state, when we do jury verdict searches to determine how similar cases were decided and settled for, taking into consideration the injuries, the person's age, how much time they lost from work, all of this, we can come up with an evaluation or at least a range of the injuries. So we take the percentage of liability times the evaluation of the injuries, and we come up with an evaluation of the case. It's never exact, but there's a range. There's a range in which we can determine what the value of a case is. Some cases are very, very difficult to evaluate. Our funeral home neglect cases are very tough to evaluate because there is not a large history of funeral home neglect or records of these cases being settled or tried to a verdict. But I'll give you one secret that nobody really knows about. But I'll give you one secret that nobody likes to talk about. And I can tell you because I used to do insurance defense work. Insurance companies hate risk. They hate risk. They hate the fear of the unknown. So if you have a case that is difficult to evaluate, insurance companies don't like that. And if you have an attorney who is willing to go to trial, insurance companies do not like having 6 unknown people determine what the value of that case will be. So it is important to hire an attorney that has tried cases and is willing to go to trial if your case can't settle. Those cases take longer. If you're taking a case from beginning to a verdict, those cases are going to take several years to get a resolution. Once you have an evaluation of your case and you know what the range is or should be, we take into consideration the policy limits, because that will determine the likelihood of your case resolving sooner rather than later. You have good liability, a significant injury, and small insurance, your case is going to resolve a lot quicker. You won't get the justice you deserve, but you will get a much quicker resolution. So generally, smaller policies resolve a lot quicker than larger ones. Sometimes they take longer because sometimes the insurance company will play a game of chicken. They are going to dare you to file a lawsuit when the policy limits are only $25,000, and that's probably your maximum recovery, because they don't think you're going to do it, because it costs money to start a lawsuit, to get a process server, to hire an expert to come to trial. But you know what? If you have a case that's worth $25,000 and the insurance company isn't paying it, there is a thing called bad faith, and you can get more than the policy limits if you are successful at trial and you proceed on a bad faith claim. If you want to know more about bad faith, watch my video on bad faith litigation. Cases with higher policy limits usually take longer because you really need to have a crystal clear picture of what the injury situation is before resolving the case. Because once a case is resolved, you cannot come back and reopen it and get more money. So if a doctor is suggesting you have surgery or injections or invasive procedure and you're putting it off because you don't want to do it, you're afraid of going under the knife, you're afraid of what the results will be, you're not guaranteed that it's going to make you better, and you really don't want the inconvenience of having to have surgery, the insurance company is going to throw that in your face and lowball you. So it's better to keep the case open longer if you are continuously getting treatment, and the possibility of future treatment such as surgery or injections or whatever it is possible, because the insurance companies will pay more once you have the surgery or once you have the injection. But if the doctor recommends it and you don't get it, they're going to dare you. They're going to dare you to take the money, to get a quick resolution, or to go have the surgery. They're not going to be too happy when you have the surgery and they end up having to pay more. This is the timeline on how we process cases. When a case comes into our office and a client engages us as their attorneys, we immediately send out what's called a letter of representation. That is a letter to the defendant. Sometimes if we know the insurance company in advance, we'll send it directly to the insurance company. But if we don't know who the insurance company is, we send a letter to the defendant, person who will be sued, that is the person who caused the accident and the injuries. We request that they forward it to their insurance, because without the insurance information, we're not going anywhere. Within 30 to 60 days, we know who the insurance company is, and its claims adjuster will be assigned. Sometimes we know the policy limits sooner rather than later. Sometimes we won't know the policy limits unless we engage in litigation. Now, while we're waiting for the insurance company information, we're doing our own investigation and discovery. We're getting medical records, we're getting photographs, we're getting witness statements, we're determining who the witnesses are, and we're evaluating the liability situation, and we start to evaluate what your injury situation is. In 3 to 6 months, we have enough information to send to the insurance company so they can begin their evaluation. Again, these are general rules. Sometimes it's a little quicker, sometimes it's longer. Once the insurance company has a package of medical records, a police report, photographs, we're kind of at their mercy to conduct their evaluation and to come up with a number, and whether or not they want to try to resolve the case or whether they want to force us into litigation. If they're dragging their feet and they're playing games, then we will start a lawsuit. However, we do make an attempt to resolve most cases for just filing a lawsuit, because once we file a lawsuit, the answer to how long will my case take is usually at least 3 to 5 years if we're lucky. Now, once the insurance company conducts their evaluation and they decide whether or not they want to try to resolve the case or whether or not they want to proceed to litigation, we start negotiating and try to reach a resolution that will make the client happy. I have had cases where the clients say, I don't want to go for treatment. For the most part, I'm feeling better. I just want this to be over, and we will resolve the case. I have clients that no matter what we get and no matter what the policy limits are, it's never going to be enough. In those cases, we will drop into suit sooner rather than later, because there's no sense in wasting time on cases that we're not going to be able to settle. Generally, within 10 months to a year, we will know whether or not the case is going to be resolved or put into litigation. As I told you, cases with bigger policies typically take longer. Premises cases usually take longer because there are usually multiple parties pointing the finger at each other as to who is responsible, if anyone, for the happening of the accident. If a client engages us and they have significant injuries and we are suing a commercial defendant with a commercial policy, whether it's a FedEx truck or a building or whatever it is, those cases we usually will start the lawsuit right away, because there is no sense in waiting 6, 10, 12 months in order to see if we can get a resolution. Because in my experience, the likelihood of getting a resolution, and due to the significance of the injuries, is not worth trying to save some time in order to resolve it. Case is going to take long. We advise the client this is what we're doing. In those cases, again, will take 3 to 5 years. Sometimes it's longer, sometimes it's shorter. Sometimes cases will settle right after we start a lawsuit. Sometimes they'll settle in the middle of litigation. Key event in any case is depositions. Once the plaintiff testifies, if they make a good witness, sometimes that will help facilitate a settlement. Sometimes it won't. If they're a bad witness, it will cause the insurance companies to dig their heels in, and the case will take longer. So once a case is put into litigation, why does it take 3 to 5 years? Let me tell you, there's a process called discovery. So the first year or two, the parties exchange information. Plaintiffs, we send the defendants and their insurance companies authorizations to get their own medical records, despite the fact that we send them the medical records ourselves, because they don't want to trust the records that we're saying. They need to get them themselves. So they usually will have 2 sets of medical records. Then we have to schedule depositions. The more parties there are, the tougher it is to schedule depositions. If it's a one-on-one where one person is suing another person, it's a lot easier. But if there are multiple parties, again, sometimes there are multiple car accidents. In premises cases, there are various defendants that are pointing the fingers at each other. those are tougher to schedule. So that process will take longer. But by the time we exchange medical record authorizations, they send us their insurance company information, they send us their defendant's information. They have to give us photographs if they have them, or witnesses if they have them, and we have to get witness statements from those people as well. This process usually will take a year to 2 years. Big factors in determining how long these cases take are the venue, what county is the case being brought in, and who is the judge. Some judges work faster than others. Some judges drag their feet and don't like to work, and these cases will take even longer. And during the course of this discovery phase, there are several conferences. First conference, guess what it's called? It's a preliminary conference, because that's the first conference, and that sets forth the timetable for which discovery shall be complete. If we're lucky, we complete the case within that timetable. More often than not, we're not so lucky. Why? Because the defendants don't want to give us information. We have to fight them tooth and nail, especially on the nursing home cases. They give us nothing without getting court involved and telling them, you have to give us the incident reports. You have to give us your own records. You have to give us the name of witnesses. They fight us tooth and nail on every single thing, and we have to go to the court multiple times, repeatedly, to get orders that continuously tell them to give us the same information over and over and over again. And you don't just call the court up and say, I would like a conference. You have to make a motion. Sometimes it could take 6 months to get the motion decided. Sometimes the court will take 3 months to schedule a conference if you're not going to do a motion. It is a very slow, arduous, and torturous process. Now, once discovery is complete, and it's complete when we say we have everything we need, we don't need anything else. The defendants say we have everything we need, we don't need anything else, and we can agree, we can certify the case for trial. We file a document called a note of issue, and that places the case on the trial calendar. The trial calendar, in and of itself, is a process. You can put a case on the trial calendar tomorrow, and you're not getting a trial date for at least 2 years out, a year and a half in certain counties if you're lucky, but in most counties it's at least 2 years, if not longer. It could take a year before you see the courthouse again, and you go back and they'll have what's called a pretrial conference. In Brooklyn, they just tell you to come back on another date. I was in Brooklyn last week and they said come back in December. We didn't see a judge. My adversary didn't even show up. If we're lucky, we will get a trial sometime in 2027. So once you're placed on the trial calendar, your case moves up, and eventually you will get a trial. But that is why the process takes so long. Let me tell you about 2 cases I had. One took a very long time, one was resolved within a matter of months. The first case involved a drunk driver who killed my client. He only had $100,000 worth of insurance coverage. My client was 50 years old. He had a very good job, making a couple $100,000 a year. His pain and suffering was horrific. His wrongful death claim, which takes into consideration the amount he was earning, who he was supporting, was worth millions. The insurance company who was insuring the driver with only $100,000 in coverage tendered the policy limits to my client within 48 hours of the accident. However, in light of the magnitude of the injuries and the devastation the defendant caused to my client and his family, could not just turn around and accept $100,000 no matter how quick they offered it. We wanted to get my clients as much as possible in order to compensate them for what has been taken away. This was the sole supporter of their family who was paying the mortgage, buying the food, paying for their doctor's visits, their kids' education. They were going to private Catholic school. $100,000 was not going to cut it. So we looked, there were no additional insurance policies within the household, but in New York State, you can sue the person. It's called the Dram Shop Act. Under the Dram Shop Act, we can sue the people that were serving the defendant alcohol that caused him to be intoxicated. We found out he was coming from a bar. He was highly intoxicated. He survived the accident, by the way, and the hospital record showed his blood alcohol level was at least twice the legal limit. So we found out the bar he was coming from. We conducted a very extensive investigation. We were getting ATM receipts to show that he was withdrawing money from a bank across the street from the bar. We deposed the bartenders, the bouncer, and we were able to establish that he was at the bar. We got video from the ATM machine showing that he was at the ATM across the street from the bar. The bartenders and the bouncers identified him, but the bar still didn't want to pay, right? They do what insurance companies do. They fight you tooth and nail and do not want to pay. But we pushed the case along. We got a trial date. And what I said earlier, remember, insurance companies do not like risk. And they knew that the likelihood of a big verdict was coming, especially in light of these circumstances where this case was probably one of the most tragic cases I have ever handled. And we went to mediation. They had $1 million in insurance coverage, and they paid close to the policy limits. The reason we settled for just under the policy limits and didn't hold out for the whole policy was, one, my client needed the money, and two, nothing's guaranteed. There is nothing guaranteed. Although I liked our chances of succeeding going in, and if we were successful, we would have gotten a verdict far in excess of the policy limits. When they came this close, it was not worth the risk to my client to turn away that offer, to spend at least a month in trial. This case would have probably taken closer to 2 months by the time we brought in all the evidence and all the witnesses, and she wanted the case over and did not want to relive the events of the last couple of years. So that case took about 5 or 6 years. Now the second case we resolved last year. We signed it up last year. We resolved it last year. A woman was walking in a parking lot. She was struck by a car, knocked her down. She broke her pelvis. She was immediately taken to the hospital. She spent a month in the hospital. Then she was transferred from the hospital to a rehab. She was 85 years old. We got the hospital records. We got the video from the parking lot. We got photographs of the injuries, and we got the records from the rehab. We sent them into the insurance company, and within 6 months, that case was resolved for the policy limits of $500,000. In that case, we did not have to file a lawsuit. We got the records quickly, and we resolved it quickly. And the insurance company knew that if they did not resolve that case, we would have pursued a bad faith action when we got a verdict in excess of the policy limits, because it was the same insurance company that refused to settle a case with us a couple of years ago. We won, got a verdict in excess of the insurance policy limits, and we filed a bad faith case, and then they paid on the judgment. So in the case of the pedestrian knockdown, we had good liability. We had significant injuries. We met the serious injury threshold of New York State because she had a fracture. She was hospitalized, and the liability was clear, the injuries were clear, the insurance policy limits were high enough to fairly compensate the client, but low enough that the insurance company did not want to take a chance on litigating a bad faith action. A side note is, when you're over 70 years old in New York State, you're entitled to a special preference. So that case, if we filed a lawsuit, would not have taken 3 to 5 years to come to trial. Probably would have come to trial within a year, maybe 2 years, because we would have pushed discovery through. We didn't really need a lot from the defendants. We didn't really need the defendant's deposition because my client was able to testify what happened. Police report was favorable, and we would have just filed a note of issue right away, made a motion for a special preference, and we would have gotten a trial date within a very short period of time. Things you can do to get a quick resolution in your personal injury case: 1, hire the right attorney. Hire an attorney that's going to communicate with you, that knows what's going on as far as your treatment goes, and that knows what they're doing in order to investigate the case, get the information they need to get to the insurance company as quickly as possible. They know what witnesses to get. They know what photographs to get. They know to get your medical records right away. Don't hire an attorney that's going to treat you as a number, put your case in the drawer, and let nature take its course, and eventually the case will resolve. You need to hire an attorney that's proactive, that's calling you, not waiting for you to call them. But if you do call them, we'll call you back immediately. Get medical treatment, get medical treatment, get medical treatment, get medical treatment. Get it sooner rather than later, because the longer you wait to get medical treatment following an accident, the better the argument you're making for the insurance company to say your injuries were not caused by the accident. The insurance company will say, well, they didn't go to the hospital right away. They waited 2 or 3 days. The reality is like I said, most people are not litigious. Most people are not looking for a lawsuit. But when you delay in getting your medical treatment, you're giving the insurance company ammunition not to pay. Get your medical treatment, get your injuries documented, go for the diagnostic testing. It's not going to heal on its own. You don't know how many times clients come to me and say, well, I'm waiting to see, it's going to get better, I don't have the time to go for the treatment, I can't take off of work. Go for the testing, get the diagnosis, so your attorney can get those records and send them to the insurance company. The longer you wait, the longer it's going to take your case to resolve. Cooperate with your attorney. You have no idea how many clients hire us and then don't return our calls. They don't return text messages. They don't return emails. We are at a point where when we are engaged by a client, one of the questions we will ask is, give us an emergency contact person. Sometimes it's not within the client's control, but sometimes the clients just ignore us and they don't communicate with us. Let us know what's going on so we can get updated medical records when you're going to a new doctor, when you're going for additional treatment, if you're going for testing, if you're getting injections. Communicate with your attorneys. Please. Factors that cause delays in reaching a resolution on your personal injury case. 1, getting the wrong attorney. Hire an attorney that is not responsive and is not working on your case. It's not going to resolve soon. It's going to take years. Communicate with your attorney, as I mentioned before. If you don't communicate with your attorney's not going to know what's going on. Worse is if you have an attorney that is not proactive and is not reaching out to you and you're not reaching out to them, you're lucky if your case will ever get resolved. 3, court system. The court system is backed up, and not all the judges have your best interest at heart. Some of the judges are elected, they're political elections, and they're appointed or they're elected because of politics and not on the merit. Judges that don't want to work and have no interest in moving your case are not going to facilitate settlements. There are some judges that are great. There are some judges that will bring you in and they will lock you in a room and they will do everything they can to settle your case sooner rather than later. There are other judges, they just don't care, and they will never make an attempt to settle your case. Another factor is the county in which your case is brought. If you have a case in upstate New York, those cases move quicker. Cases in Westchester move quicker than cases in the 5 boroughs. New York City, Manhattan, the Bronx, Brooklyn, they have the highest number of cases in the state, and those courthouses take longer to move your cases along because there are just so many cases, and they don't necessarily have more judges. More defendants there are in a case, the longer the case will take because there are more schedules to coordinate for court appearances, for depositions, which means each party gets to ask the other party's questions about how the accident happened. Those cases can take a year just to get to depositions, sometimes longer, and they're pointing fingers at each other. And invariably, you're going to deal with motions to dismiss. And if they're not providing you with the discovery you need, you have to make motions to compel them to provide you the information you're entitled to. Unexpected turns in treatment can also cause delays for several reasons. Because if new treatment is suggested and you get it, and your case is on the trial calendar, guess what? You may have to take your case off the trial calendar and re-engage in the process known as discovery so the other side can get your additional medical records. They can take another deposition. They can have another physical examination of you. This can delay the case tremendously, especially if you've worked so hard for the past 3 or 4 years and the case is on the trial calendar. This is a setback and will double the time it will take for your case to come to a resolution. Another reason unexpected treatment can delay your case is if the doctor tells you you have a new injury or you need additional treatment, you may require surgery. You can't in good conscience resolve your case knowing that you may need future treatment and possibly surgery until you know whether you're going to have it or you're not going to have it. The insurance company is not going to pay you based upon, well, you may have the surgery. Not only are you entitled to the pain and suffering for having to undergo the surgery, not only does the surgery indicate the significance of your injury, you can make a claim for the cost of the surgery and the cost of the recovery for the surgery, any therapy that's involved. All of those are factors that go into your compensation, and no attorney in good conscience is going to resolve your case with all of these questions looming, especially if there is a big policy in play, because once your case is resolved, you cannot go back and say, you know what, my case was resolved 2 years ago, but I now need surgery and you're going to need to pay me for it. And you need to pay me for the cost of the surgery and the cost of the future treatment. It's never going to happen because when you resolve a case, you sign a general release. And the general release says, I release you from whole claims from now until the end of time. The release actually says that. And you cannot then go back and say, pay me for my additional pain and suffering, because you're done. You're done. you're done, and you can never do it. Clients are often frustrated when I give them this long-winded answer to the question, how long is my case going to take? Because they don't want to hear the typical lawyer answer that says, it depends. And that is a typical lawyer answer, and I hate giving that answer. But the reality is there really is no clear-cut, direct answer to that question. As you can see, there are many factors that go into determining how long your personal injury case will take. However, there is one factor most clients don't even realize, and I haven't even touched upon it, and that is your attorney wants to resolve your case as quickly as you do, if not faster. Why? Because we don't get paid until there's a recovery. We're working on your case until we resolve it and we get paid. We're laying out money to pursue your case until there's a resolution and we can get our case disbursements back and we can get paid. So our incentive is united with your incentive. We want to get you as much money as you can to make you whole and to make sure you're fairly compensated, but we don't get paid until our job is done. And we want to resolve the case quickly and swiftly, but not at your expense. You or a loved one have been injured through the negligence of others. Ring Rizzuto at 800-666-5555. If you found this information helpful, hit the like button, subscribe to the channel, follow, and I will see you next time.